Your lawyer started your medical malpractice case because his medical expert told him that you had a valid and meritorious case. What happens, though, if during the course of your lawsuit, the expert reevaluates additional materials, additional records, and now determines that you no longer have a valid case? What happens to your case then? You want to know the answer? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. You, my friend, have a problem, a big problem. In New York, the only way you can actually get started with a medical malpractice case is to have confirmation by a medical expert that, number one, your doctor was careless, number two, that his carelessness was a cause of your injury, and number three, that your injury is significant and or permanent. Only after a medical expert gives your attorney all of those things can he go ahead and ethically and properly start a lawsuit on your behalf. Now, what happens if during the course of your lawsuit, new information comes to light? New medical records come to light which your attorney and your expert did not have at the very beginning of the case when the expert reviewed your records. Now it changes things. The expert now turns around and says, hey, I didn't have this information at the beginning, and if I had it at the beginning, I never would have told you that there was a valid case here. Now that I do have this information, guess what? It is my opinion, that the expert says, that there is no valid case. Now you've got a big problem. You've got a big dilemma. You are going forward full speed ahead with your particular case, and if your case goes all the way to trial, guess what? You won't be able to go to trial because in New York, you are required to have a medical expert come in and testify to support your claims that the doctor was careless and that his carelessness caused your harm and injury. If you don't have a medical expert to support your case, the judge will throw your case out after your attorney has finished putting on whatever proof is necessary to go forward with your case. That's known as making a motion for summary judgment at the conclusion of your proof. And that, again, that's a position you don't want to be in. And your attorney will know that there's no possible way you can have your case go to verdict, because if you don't have a medical expert to support your position, the judge will throw your case out, because the moment your attorney says, Your Honor, the plaintiff rests, meaning that he has no more evidence to go ahead and support your case, the defense attorney is going to jump up as if an ejection button has been pressed and now ask the court to throw your case out, and the judge would have no issue, no problem to go ahead and do that, because the law in New York requires that you have a medical expert testify to support your case. So what options do you have if this occurs? One option, the main option that you have, is that your attorney tries to find another medical expert to support your case. He's now going to send all the medical records, not just some of them, but all the medical records that he has obtained on your behalf to this new medical expert, and now await word from the expert to see if he believes that there is a valid case. If there is a valid case, great, now you continue proceeding all the way towards trial. But what happens if the second medical expert now comes back and says, I'm sorry, I do not see that there's a valid basis for a case? In that instance, you've got a significant problem. Now your attorney is stuck. He's got a case that he now knows cannot be prosecuted because he doesn't have a valid, qualified expert to support your position anymore. Now you're both in a very bad position. Your attorney has spent a great deal of time and effort and money and resources to prosecute your case. He has laid money out of his own pocket to go ahead and pay for the expenses associated with prosecuting your case. If you don't have a valid case at this point, there's really only one option the attorney has, and that is to withdraw as your attorney. Well, I shouldn't say that. There is another option. The other option would be to try and find another medical expert who now comes to a different conclusion than the first two experts did. The likelihood of that happening is not very good. So, what realistically are your options? Well, in all likelihood, your attorney is going to come to you and tell you, I'm sorry, I can't proceed forward with your case because we don't have medical experts to support your claim. In that instance, your attorney is going to have to withdraw as your attorney. And once that happens, the defense will pretty much know, even though they won't know exactly and won't know the specifics, because your attorney will not divulge that information, and there's no reason to divulge that. But they know that the only time an attorney is going to withdraw as the lawyer representing you in what was otherwise a valid case typically is when they can no longer find a medical expert to support their case. And that's a great thing for the defense, a terrible thing for you. So in all likelihood, the court is going to allow your attorney to withdraw, which means that you are going to have to try and find another attorney to continue prosecuting your case. And that's going to be a huge challenge for you, because any other attorney that you go to is going to know, okay, there are issues that have arisen with the medical experts in your case. Are they willing to take a risk to go ahead and lay out money knowing that there is a good chance an expert will come back and say, sorry, there's no valid basis for a case? But that is a possibility. So let's go back to the question that I raised at the beginning of this video. What happens in that instance where now the medical expert has changed their opinion and now you're stuck in the middle of the case? In all likelihood, after getting another expert who comes back with the same negative opinion, even if you decide to go with a third medical expert, you run the risk of also getting the same expert opinion, a negative opinion, in which case you're stuck and your attorney will likely withdraw. So why do I share this with you? I share this with you because this happens from time to time, not frequently, but from time to time, where the expert initially did not review or did not have all the available medical records and medical information needed to reach a proper conclusion about whether or not you had a valid case. And if it turns out later that now his opinion has changed, guess what? Now your entire case will have changed. So why do I share this quick information with you? I share it with you just to open your eyes and help you understand how these types of cases work in the state of New York. You know, I recognize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are still thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.